The purpose of the Labour Relations Act is to regulate the relationship between the employer on the one hand and the employee. And it also seeks to regulate the relationship between the employers' association as a collective and the trade union on the other hand. And the amendments that we have seen they seek to address the issue to regulate the subcontracting and the fixed-term contract of the employees and the outsourcing. There's going to be a change, which means that an employee who's armed with an award does not have to go and get a warrant of execution. If the award is certified by the CCMA, that employee can use that award to attach the assets of the employer. That's a meaningful change in the sense that now the CCMA will be able to intervene, for instance, in an industrial action, either by request from the parties, or if the CCMA is of the view that the dispute between the parties is that of public interest. And the important element of that amendment is that once the CCMA intervenes in a dispute between an employer and the trade union, the industrial action is suspended. The Act makes changes or makes an additional obligation or give the employees at least certain rights. When they're employed on a fixed term employment, not only would they have a legitimate expectation to have their contract of employment be renewed, but they will also have a legitimate expectation to be employed indefinitely. The amendment includes a client company as party to the unfair labor practice. But we don't know what is the client company, but one can assume that if an employee who alleges that there was an unfair labor practice would also include or make those allegations against a temporary employment service. The current legislation allows every employee to refer a dispute of unfair dismissal to the CCMA. But the amendments propose that people who earn more than 149,000, which is prescribed by the minister, would not be able to refer their dispute, which in relation to their dismissal, they will have to refer their disputes to the Labour Court as opposed to the CCMA. An employee who is retrenched and is a single employee has an option whether to go to the Labour Court or to go to the CCMA. Employees who are employed by one employer, if that employer sells that business to another employer, those employees should be automatically transferred to the employer who bought the business. The contract of employment is defined to mean common law of contract. And what is significant in that definition is that the definition goes further and say any form of arrangement or agreement will be a contract of employment. All employees who render services to an employer would be regarded as employees, irrespective of the arrangement. The independent contractor is a person who has to come up with a product and is not supposed to be under the supervision of the employer. What this amendment seeks to do is to give the powers to the CCMA to vary the certificate which it has issued, the certificate of outcome.